Hey guys, I'm Zach Threadgill, and welcome to episode 5 of the S.S.O show, where we teach you how to seriously stand out. The S.S.O show is brought to you by www.auctionhousebeats.com. For this episode, we've decided to release the entire interview with attorney Blake Iverson. We felt that in previous episodes, it would have been a lot more challenging to understand had we not gone through and explained the whole copyrights and some of the terminology that we used. So for this episode, we decided to go back and bring you the entire thing so that you can kind of put together the pieces. If you haven't seen episodes 3 and 4 already, I'd highly encourage you to go back now and look at those, because the terms that we define there as far as the copyright stuff is going to lead into the questions that we ask Blake. So without further ado, guys, here is the interview with attorney Blake Iverson. Do you mind introducing who you are, what your credentials are, how long you've been practicing law, everything like that?
Sure. I'm Blake Iverson. I'm an attorney with the law firm Iverson Felsheim. I've been practicing entertainment law in Minnesota for 14 years.
Okay, awesome. Well, so what it is, Blake, is our next episode here is we're looking at copyrights. And we're looking at, protecting beat makers as well as artists. And we're trying to look at just the whole perspective on it, and to just get people thinking about owning the copyrights is how you make money in the industry. And really trying to teach how the money is moved. So based on our episode, I had some questions that I wanted to bring to you that we've gotten from other people. Okay, so my first question here that we've got is, what are some things that the performing arts protects? Like, because we're comparing the performing arts versus a sound recording. What's like the difference there?
So you mean a live performance? Is that what you mean by performing arts?
So, okay, so when you copyright, say for copyrighting a song, there's the two parts of it, right? There's the actual sound recording, and then there's the
composition.
Composition, yes. What is the difference between those two things?
Sure. So the copyright in a song, the original copyright in a song is usually the composition, right? It is the sheet music, the track that you build, right? And then usually the sound recording is a derivative work of the composition. Now in practice, it doesn't always work that way, because not everybody sits, we're not all Mozart. We don't write on, ledger paper. You might compose in real time, and the first thing you make, the only thing you make is the sound recording. So a copyright is fixed as soon as the work is fixed in a tangible medium. And we generally view it that the composition is the original copyright, and the sound recording is a derivative work of it. It is the expression of what is on the sheet music, let's say. So that's how those copyrights differ. The longer held right is the composition right. That's been around for a long time. It wasn't until 1972 that sound recordings were covered by copyright. So really, in a performance, in a live performance of a song, again, the right that is at issue there is the composition copyright, because the sound recording doesn't come into play in a live performance of a song generally.
Okay.
Of course, they can get more complicated, when we think about somebody is constructing a beat on their computer, and they may be using that as a backing track to perform live, and in which case it would be, using both copyrights.
Okay, so I'm trying to make sure we kind of get a clear understanding. Could it work like this? Would you say then, like, say a beat maker makes a beat and he's got like the chord progression and all the drums and all of those things, and then he releases the final mastered beat and he releases that would be the sound recording, correct?
Yep.
And then the actual structure of everything, the melody, the chord progression, the drums, that right there in itself is what we're talking about when we're talking about the separate composition, the underlying.
Yep. The underlying work. Exactly. Yep.
Okay, so then that kind of segues into like my next question here is, let's say I do copyright a song, right? And I have the underlying work, and it's got like a good chord progression. And then let's say I do a remix of it and we put on some new instruments. I wrote the lyrics to it. The lyrics are all staying the same.
Mm-hmm.
So do I need to re-copyright this song before I send it out to other people? Or like if I want to get a feature artist, so I want to make sure it's protected, do I need to re-copyright because the composition has new instruments on it? Or am I still protected? Like, are my lyrics good and everything there? Or do you kind of get what I'm asking?
I think I do. So a remix is a derivative work of, both the composition and the sound recording, right? So you're taking the parts that already exist and you're adding to it. And so only the person who owns the copyright has the right to do that unless they grant somebody else a license to do that. So, I think the answer is that it depends. You can, right? The answer from a lawyer is always it depends. But in this case, what we're talking about is whether a remix has so substantially altered the work that it is necessary to apply for a separate copyright for a derivative work, of those two existing copyrights. And probably the answer, a lot of times is yes, because it has fundamentally changed the characteristic of it. As long as that recording doesn't match the composition, so if you were to say, okay, so this is in 4/4 and it's in C, it just, from the music notation side of it. Yep. And then your remix is in 6/8 and it's got, and it's in D, right? So that's not so you have fundamentally changed the composition. It is a new composition that relies on those existing copyrights. So that would be an additional copyright in the sound recording.
Okay, so derivative works now we just kind of brought up here. So let's backtrack just a hair and let's talk about derivative works for 1 second. What is a derivative work and how does that pertain to beat makers?
Sure. So a derivative work is a new work that is created utilizing an existing copyright, right? So if you make a beat, you are the owner of that. If you make a track, you're the owner of that, right? You create it, you fix it in tangible medium. It's an original work, fixed in tangible medium. Those are the two criteria for copyright. So you then, you've got your composition, you've got your sound recording of that track. Now, as a beat maker, if you want to license that track to a rapper, for instance, then that person is going to create, that when they add their vocals to it, they're creating a derivative work because it is derivative of your original copyrighted works. In this case, two of them, right? The composition, the original composition, and the original sound recording. They're making a new sound recording using elements of yours. So that's why it requires a license from you as the person who created the beat in order to grant them the license to create that. So any beat maker who is, selling their things to a performer, selling their beats to a performer, is inviting someone to make a derivative work.
Okay, and so that is a right of the copyright holder or whoever owns it to license the derivative work. Correct. And all that means is anybody can take your work and create something new out of it, but they need your permission, correct?
They need your permission. Yep. So it's, I would think of it the opposite way. I would say no one can do it unless they have your permission.
Oh, okay.
Right?
Awesome.
Yeah. Yep. Because it's an exclusive right of a copyright holder to grant that right to create derivative works.
Okay. So then my next question is, regarding sampling, because sampling, I would assume then sounds like it would also be a derivative work because you're pulling copyrighted material out of something that's already been released and then incorporating it into a new project.
Yep.
So is there any way to sample without infringing on a copyright? Say, is there any special rule, like you can use 4 bars or anything like that? Because there's
some wives' tales out there. There are a lot of wives' tales about 7 seconds or 4 bars, or the issue is really whether it is recognizable as somebody else's work. If somebody can say, "Hey, that's mine," obviously the most sampled drum track is Funky Drummer, Clyde Stubblefield playing with James Brown, right? There's a million hip hop tracks built off of that, and it's immediately recognizable. And, like when beat makers like yourself are putting things together, when, if they are sampling, they're looking for that perfect hi-hat clap. They're looking for that perfect kick drum sound, that perfect snare, right? And so if you find that in a place where it exists on a recording and you just sample that, then the question is it recognizable or not? And what the court looks at is whether the only thing that's permissible is if it's de minimis, if it's so small and so insignificant that it isn't, it isn't part of the, pardon me, it isn't part of the, an essential part of the original composition. So if you want to sample it, there's probably a reason you want to sample it. And that means that it is probably not de minimis. So I'm always very wary of, of sampling, because it is, it is just rife with peril. If you're not clearing the samples, like, you are opening yourself up to legal liability.
Okay. So my next question is, whose responsibility is it to clear a sample, the artist or the beat maker?
Depends who put the sample in it, right? I mean, so if you built a track and put a sample in it, and this is where it gets tough, because you have to remember, you have to clear 2 copyrights. You have to clear a copyright on the composition and on the sound recording, and those are probably not owned by the same person. The publishing, the composition is probably owned by the songwriter and a publisher, whereas the sound recording is probably owned by the record label that released that. So you are chasing down 2 parties and paying 2 license fees in order to clear a sample. And if that is part of your track that you are releasing into the world, then your track is a derivative work because it includes that sample, and you don't have the right to use it unless you clear those licenses.
Okay, so really what I'm hearing is, guys, don't sample. I mean, unfortunately, as much as we want to, and it's awesome, if you're not clearing it, this can lead to big problems. And I'm assuming that can lead to lawsuits, correct?
Absolutely. And I will tell you that any recording contract that you sign with any label who knows anything, all the contracts that I've seen say, this is my original work, and or I have licenses for everything that's not my original work. In hip hop, they're especially strong about saying, this work does not contain any uncleared samples, and you have to provide them the license, the proof of license, if you are including a sample. So if you really need that sample, you've got to do the work to get it.
Okay. Well then, my last kind of question to finish up here then would be, since we're talking about sampling and loops and things like that, how would a royalty-free loop or sample work in terms of a copyright? Say you pulled a loop off of Splice, or you purchased it off somewhere else and it's labeled royalty-free, and you've got this paperwork, but then you make a new beat afterwards. Can you still copyright that beat?
Yeah. So as long as you have purchased it and it says you don't, I mean, it is all subject to the language in the agreement that you purchased that probably no one reads, that you probably click a box and click through and don't read. That probably dictates how you're supposed to be able to use it, right? It says no royalties. Does it say that you have an unlimited license, a perpetual license, a worldwide royalty-free license? That language gives you broad rights, and it may say you have a license to do this, but you have to attribute, so-and-so as a songwriter on there, even though they aren't entitled to any royalties. I mean, they may ask that you credit them somehow. So basically you can do almost anything by contract. So the question is what the contract says. So if you're buying a royalty-free, loop, something, you would want to look at the, the disclaimer language or the warranty language or any of the contract language that governs that your purchase. And you want to make sure you have those rights. I mean, I would be wary of buying something from someone who said, no royalties, just pay me, but it didn't actually say anything. Because how are you going to prove that if you make $1 million? I mean, I tell you, if you make $1 million on something, someone is going, and anyone thinks they have any right to it, they're going to come after you for it. If you're toiling in obscurity, if you're not making any money, the chances that somebody's going to sue you for this are pretty low. But as soon as something is successful, if you've got anything that the rights are not clear about, and this goes to like, this happens a lot in the indie music world where you have your friends play on an album. You have, somebody sing background vocals or play guitar or whatever, and you might thank them in the credits. But if you didn't give them a work for hire agreement and have them sign it and pay them whatever you'd agreed to, then if you are successful, they can come after you and say, I was not compensated for my contribution here. And this song's now a hit. So my contribution has value. So instead of paying somebody $50 or $100, to sign a work for hire, they're now coming after you for a third of the value of the composition and the sound recording, something like that.
Oh,
so,
okay.
Always, my advice is always do paperwork.
Okay.
Make sure you get the paperwork done. Like, good contracts make for good friends.
Okay.
Because everyone does things. Everyone thinks like, oh, you're my pal, we don't need to have a contract. And I will tell you, relationships go south when people don't have contracts.
Yeah. Okay. So then my last kind of thing is so because we've learned that copyrights are so important, how can somebody protect themselves? What's the easiest way? You make a song, what do you do?
The copyright website is copyright.gov, and there are video tutorials on copyright.gov for you to submit a copyright application.
Okay.
When you get a common law copyright as soon as you fix something in a tangible medium. But if you ever need to sue somebody for infringing your copyright, you have to have had a registered copyright before they infringed upon it, in order to go after them for attorney's fees and statutory damages, which are often more than actual damages. So it is, you don't necessarily need a lawyer to do it. I say this to clients all the time. Check out copyright.gov, see if you think you can handle it. If you can handle it, you should do your own copyright. If you can't, contact an attorney.
Yep. And from what I've seen, it's a pretty straightforward system. I just wanted to let the actual attorney say that for cover my own legal butt.
That is, you should not be advising that people practice law without a license, but the people can work for themselves and choose to register their own copyrights if they want. Yep.
All right. Well, that's I want to be respectful of your time, and I just want to say I really appreciate you taking the time out of your day to answer some questions and help out our viewers here.
Well, thanks so much for having me. I really appreciate it, Zach.
So that's going to wrap it up for today, guys. Don't forget to like, comment, subscribe to us. If you haven't checked it out, go check out www.auctionhousebeats.com. We're the world's first online beat auction house. For now, guys, keep working hard, seriously stand out, and let us know what you want to see next.